Hey guys, Matt from the Rational Rant, and today's video is going to be regarding the Office of Compassionate Use, which is the Florida Department of Health's office that is going to deal with the new legislation, Amendment 2, in Florida, which you guys know as medical marijuana in Florida. So if you visit the Florida Department of Health's website, this is their homepage. Let me go ahead and get in here. Now, if you go over to this little quick links section, there's two ways to find the Office of Compassionate Use's webpage. You can either type it in this little search bar or click this quick link here, which is obviously what I did. Let me go ahead and full screen that. So this is the little website for the Office of Compassionate Use. Now, fortunately, they do give us a timeline for a lot of the things that they're going to be implementing in regards to Amendment 2. And I find it very interesting that we're still going to have to wait several months in order to get any progress on this legislation. If we look at this little blurb here, it says Amendment 2 and the expanded qualifying medical conditions will become effective on January 3rd, 2017. Blah, blah, blah. Following Amendment 2's effective date, the department is directed to promulgate rules to implement Amendment 2 within 6 months. So I think 6 months from January, that's going to be around June. So we're going to see around June 2017 is when Amendment 2 is going to be implemented into law. And then they have another 3 months, which is going to be in August or September, in order to actually implement those regulations and get all the finer details worked out. So, unfortunately, I'm not going to have much more to give you guys in terms of procedures until they release such things in 6 months. Unless they do it earlier, which, I mean, I check this stuff regularly, so I'll make sure to keep you guys up to date. But let's go ahead and just do a little digging around on the Office of Compassionate Use's webpage here. Alright, so they give us a few definitions here. Now, I did read over this, and it's kind of conflicting, because if you guys watch my previous video, I did it on the details of Amendment 2 and the actual legislation itself, word by word. And there are some caveats in the actual legislation that they list differently here on the webpage. So look at this. Florida law permits qualified physicians to order low THC cannabis or medical cannabis for patients diagnosed with certain conditions. There are two types of cannabis products that may be ordered by qualifying physicians. One, low THC cannabis. Patients with cancer or a condition that causes chronic seizures or muscle spasms may qualify to receive low THC cannabis. Low THC cannabis has a low amount of THC, obviously. Then two is medical cannabis. If a patient is suffering from a condition determined to be terminal by two physicians, he or she may qualify for medical cannabis. This product can contain significant levels of the psychoactive ingredient THC and may produce the high commonly associated with cannabis. The department recommends speaking with your healthcare professional to determine if low THC or medical cannabis products are right for you or your loved ones. So, in the actual amendment, it says that your doctor has discretion on whether or not to prescribe low THC cannabis, along with some medical cannabis depending on the condition. So, looking at this page, it looks like they're only giving it out for certain conditions as per the diction. But if you look at the actual legislation, it's different. And this is where we're kind of getting conflicting, stories, you could say, from the Department of Health and what might be implemented. So that's why a lot of these laws are still kind of up in the air. And until the June deadline is met for those rules to be promulgated, it's going to be a little bit of a gray area until then. So, alright, let's go ahead and go to the About Us section. Basically just says a little bit of an overview on the Medical Cannabis Act. Florida's medical cannabis is cultivated, processed, and dispensed by 6 companies called dispensing organizations. The state's dispensing organizations were selected in 2015 following a thorough application process. The department is not accepting new applications at this time. Each dispensing organization is required to receive cultivation, processing, and dispensing authorizations before dispensing to patients. All 6 have received cultivation authorization and are growing cannabis in their facilities around the state. Multiple dispensing organizations have either secured dispensing authorization or are in the final stages. Now, this is also a little bit strange because in Amendment 2, they have a section that talk about caregivers. And caregivers, if you look at other states' legislation for medical cannabis, such as Colorado and California, they list caregivers basically as private growers that only grow for certain patients. It kind of takes out that middleman. But what I think is going to be happening here in Florida is you're going to have caregivers, but the caregivers, which are going to be smaller independent growers that have, kind of a network of patients, might be shipping their cannabis to these 6 dispensing organizations. They might be the ones who process it uh, and dispense it and get it ready for, medical consumption in the storefront. Um, Once again, I mean, this isn't very, very clear just because of how little the Department of Health has given us. So that's what I think is going to happen. But obviously, that could change. And, you know, it's all still a little bit up in the air. So let's go to the patients section. All right. A patient qualified to receive an order for low THC cannabis or medical cannabis must be a permanent resident of Florida, a patient of the ordering physician for at least 3 months, and be diagnosed with a qualifying medical condition. So that is interesting because I did not read anything about this part, the patient ordering from the physician for at least 3 months. That means that you can't just go to a random doctor and have them give you a card, basically. You have to have some rapport with your doctor. I don't know how they're going to be able to prove that, and I'm not quite sure how that's going to be regulated, but I would imagine that there's going to be some things that patients can do in order to, maybe bypass that, but I don't know. Because once again, we don't know what the procedures are, and that is a big, big thing here. So they give you hotlines to find qualified physicians. Let's see, who qualifies for low THC cannabis? And they say that low THC cannabis is anything that has 1% THC or under. Cancer or a physical medical condition that chronically produces symptoms of seizures or severe and persistent muscle spasms. To alleviate symptoms of such disease, disorder, or condition, or if there is no satisfactory alternative treatment options for the qualifying patient. That is worded very strangely because that still almost seems like doctors have room for discretion in who they prescribe cannabis to. So it doesn't necessarily have to be just for seizures and severe and persistent muscle spasms. So that's very, very kind of strange. Who qualifies for medical cannabis? A qualified physician may order a medical cannabis for an eligible patient with a terminal condition that is attested to by the patient's physician and confirmed by a second independent evaluation by a board-certified physician in an appropriate specialty for that condition. Florida defines a terminal condition as progressive disease or medical or surgical condition that causes significant functional impairment that is not considered by a treating physician to be reversible even with the administration of available treatment options currently approved by the FDA. and without the administration of life-sustaining procedures will result in the death within 1 year of diagnosis if the condition runs its normal course. Uh, so basically, that's like cancer. All right, the medical use of low THC cannabis or medical cannabis does not include the following: the possession, use, or administration of low THC cannabis or medical cannabis by smoking. Okay. The transfer of low THC cannabis or medical cannabis to a person that is not other than a qualified patient, if that makes sense. The use or administration of low THC cannabis or medical cannabis on any form of public transportation in any public place. Okay, so both of these we already knew were in the legislation, but this one is very strange. The possession, use, or administration of low THC cannabis or medical cannabis by smoking. So that kind of goes against the amendment itself once again, because that's one of the ways you ingest it. If they really mean that, that means you're only going to be able to have edibles, tinctures, and like balms and stuff like that. So we are really getting some conflicting reports here, and I'm I don't know. Uh, just to give you guys a little bit more of a concrete position, it appears as if you can contact the Office of Compassionate Use by this phone number, 850-245-4657. Their email is compassionateuse@flhealth.gov. And they also have a mailing address, which is 4052 Bald Cypress Way, Tallahassee, Florida 32399. So I guess you're able to contact this office and get some more, you could say, caveats about this, which honestly, I might make another video in doing so, because we need to figure out why we are getting so many conflicting messages from the Department of Health in regard to this very, very important legislation. So, all right, let's go to the physicians tab. Okay, so basically, to be a physician, you just have to have an active, unrestricted license as a physician or an osteopathic physician. I don't really know what that is. Sorry. Additionally, a physician employed as a medical director by a dispensing organization may not order low THC or medical cannabis for patients. So if you actually work in the dispensing companies, you can't be a doctor or a physician that gives out such prescriptions. You have to be separate from the system itself, and you have to apply in order to get the ability to dispense. Basically defines what we've already said before. Okay, once again, this is basically all the stuff that I've mentioned before. Okay, hold on. Here's a few more caveats. A physician may not order more than a 45-day supply of low THC or medical cannabis for a patient. That is interesting. So, let's say you smoke half a gram a day, or, well, shit, I hope we can still smoke it. But, a 45-day supply, so that would be roughly an ounce and a half, depending on consumption. If some people might even smoke a gram or more a day, which that could be 45 grams. That's like an ounce and 3/4. So okay, an ordering physician must enter a low THC, but must enter an order of low THC or medical cannabis for the named patient into the compassionate use patient registry, and update the registry to reflect the contents of the order. The physician must update the registry within 7 days after any change is made. Okay, so they're going to be tracking consumption rates of patients in a database. All All right, so that's more on the physician side. They also have a little patient consent section for parents and guardians that might be looking to get cannabis for younger family members or sons and daughters. And then treatment plans. We'll just click on that real quick. Yeah, you just have to have regular doctor's appointments. All right, dispensing organizations. So we have CHT Medical, which is in Alachua County, The Green Solution, which is in Alachua County as well, True Leave, I think that's how you pronounce that, is in Gadsden County, Certera Therapeutics in Hillsborough County, Modern Health Concepts, which is in Miami-Dade, and Knox Medical, which is in Orange County. Here, we're going to look up a map of this real quick so that we can have this for you guys. Hopefully. Okay. So, if we look at this, we have the dispensing areas, you could say. Here's one in Hillsborough, which is more towards the Tampa, Orlando area. Might be where Naples want to go. People who live in Naples. I'm not sure. Miami-Dade's pretty close to South Florida as well. Orange County would be more for Central Florida around man, I'm blanking on all these Central Florida cities names, but you can look at the map here. You know where it'd be. Alachua looks like it's going to be the hub for Northeast Florida, which is where my hometown is, Jacksonville. And it's honestly farther away than I thought it would be. It's about a 2-hour drive from Jacksonville. So they're really throwing this kind of out of the blue here. And then Gadsden, that's going to be for Tallahassee and the Panhandle. So look over this for one more second, and I'm going to get away. But that looks like that's going to be the map. They're really throwing some wrenches into this thing. I just hope all this stuff isn't conflicting. So you guys can do a little bit more research, especially on the dispensing part. I'm not going to go through each of the people or each of the organizations that have applied for a dispensing license. But I do believe, as far as my knowledge goes, that caregivers and dispensaries are going to be two separate entities. The medical marijuana treatment centers and the caregivers are going to be separate. Law enforcement, I've already made a previous video on this. Basically, you just got to have your card and any identification regarding your cannabis license, and the cops can't do anything to you. Compassionate use registry, I believe that's where the patients themselves are going to register for such things. It is accessible to ordering physicians, law enforcement, dispensing organization staff, and the Office of Compassionate Use. So whenever you register to get your license, you're going to be put into this registry, and it's basically going to allow law enforcement to cross-check your license. It's going to allow physicians to do so and update the database, and you guys can put the pieces together. Resources, I'm not going to go through all these because a lot of these things we've already mentioned in the previous videos, but I do recommend you go through, do a little bit more research on here. This is kind of their timeline. I guess they do bi-weekly updates, but they really haven't. It's been more than 2 weeks since the 16th, so kind of shows how much they care at this point. And this does highlight an issue because bureaucracy creates these kind of collisions where the legislation might say one thing, but the office and their procedures might say another thing. So what is actually going to be defendable in court and what's going to be actual procedural law is still up in the air at this point, because as of now, the office and the legislation are butting heads in terms of what they're saying. So once again, I would try and call them and figure out why there are such differences, but once again, I'm going to try and make a video of me calling them and hopefully getting some answers on this. Then they have an FAQ. What are the difference between low THC and medical cannabis? We know that. Cannabis delivery service. Wow. They're going to allow delivery services. Okay. That'll be cool. That'll definitely help the drive since we know where the facilities are going to be now. Alright, yeah, we already know a lot of this stuff. So, I encourage you guys to do a little bit more digging around on this website. This is just kind of an overview of the Office of Compassionate Use's webpage. It's informative, but only to a certain point, and once again, we are seeing conflicting reports from the legislation itself to what they're stating on this webpage. So, whatever the procedures are going to be, we still have to wait, and we still have to see. But I will be here to answer any of you guys' questions. Anything you might have, just make sure to drop a comment down below. Also, make sure to smash that like button and subscribe for future videos. But thank you guys so much for watching. You guys are awesome. And remember, stay rational.